why shouldn't we treat the querying of U.S. persons out of this dragnet database, why shouldn't we treat that as a separate Fourth Amendment event requiring some additional process? Maybe a warrant, as Senator Lee has proposed, maybe some other process, but why shouldn't we say, you know, actually, yes, when you go to this massive database and ask about a U.S. person, that's a Fourth Amendment event that requires some process, some scrutiny.
Yes, and so there are two answers to that. One is a legal answer, and we've covered that a lot, but in short, we don't require the FBI agent to get a warrant before going to check the filing cabinet.
Yeah, but this is totally analogous to that, as the Hosby-Dromey Court said, right?
Sensitive records.
And as indeed the U.S. Supreme Court said in Riley. I mean, this is a completely analogous to saying that you have a piece of information down in a locker somewhere that you got pursuant to probable cause and indeed a warrant for a particular case. Here you have a massive dragnet of information. You just told me a second ago that you couldn't target the American citizens. So none of this information with the American citizens has received any process whatsoever. But now the FBI or the NSA, whomever, can go and query this database for the first time and get information on U.S. citizens, particularly for the first time, and you're telling me that that's not a separate Fourth Amendment event?
Well, Senator, I don't know what the first time. And when this information comes across the transom, there's an analyst, let's say at NSA, who's monitoring that target, or at the FBI, if it's one of their investigations, and they can read the whole thing.
It's the first time that the U.S. person has been the subject of inquiry, though. It has to be under the statute, because you told me a second ago you can't target a U.S. person.
Right.
A deep dive into one of the most urgent civil liberties debates in America today. When intelligence agencies search massive surveillance databases for information on U.S. citizens, is that a routine step or a brand new Fourth Amendment search that should require a warrant? This video breaks down the argument, the legal logic, the constitutional stakes, and why hundreds of thousands of improper searches should alarm everyone. What happens when the government already has your data and then decides to look you up? That's the heart of a debate unfolding at the highest levels of government. Not about whether intelligence agencies can collect foreign communications, but about what happens after that data is stored in a massive dragnet database. When an agency types in the name of a U.S. citizen and hits search, is that just routine analysis? Or is it something far more serious, a brand new Fourth Amendment event that should require a warrant? This isn't abstract. It's about privacy, power, and the limits of surveillance in a constitutional democracy. The government's argument is deceptively simple. They say, once information is lawfully collected, searching it later is no different than an FBI agent opening a filing cabinet. No warrant is needed to reread documents already in government possession. Courts have echoed this analogy before, comparing database searches to information stored in a locker or a file drawer. From this perspective, querying a database isn't a new search, it's just reviewing material already obtained through lawful means. Case closed, or so it seems. Here's where the logic starts to crack. Under the law, intelligence agencies are not allowed to target U.S. persons directly. Any American communications collected are supposed to be purely incidental collateral data swept up while monitoring foreign targets. That means American data enters the system with zero individualized suspicion, zero probable cause, and zero judicial process. So when an agency later searches the database specifically for a U.S. person, that's the first time that American becomes the focus of an investigation. That doesn't look like opening a filing cabinet. That looks like initiating a search. The Fourth Amendment is clear. Searches and seizures require reasonableness, and often a warrant. When an analyst deliberately queries a U.S. person's name, email, or phone number, the government is no longer passively holding data. It is actively seeking information about a specific American. That moment, the query itself, may be the true constitutional event.
It therefore follows that when you go to query the database, later, query a U.S. person in the database, that's the first time the U.S. person is the subject of the inquiry. And my question to you is, that looks an awful lot like a search and seizure for a Fourth Amendment purposes. Why shouldn't we say, yeah, okay, that's a Fourth Amendment event. We need some additional process around that.
Yeah, and Senator, I think the government has already collected this information. In many cases, an analyst may have sat there and read the email. To me, it seems passing strange to say that someone has a reasonable expectation of privacy still in something that an intelligence analyst has sat there and read as it came across in their collection stream.
Well, it just seems to me you can't have it both ways. You can't say that there's no targeting of U.S. persons that's forbidden under the statute, but then when they do want to actually target a U.S. person, they don't need any process for it. You're saying on the one hand, no process needed on the front end, no process needed on the back end. I just think, Mr. Chairman, this is an extremely, extremely important issue. 278,000 improper queries of Americans in 1 year alone. The idea that we would renew 702 without some sort of reforms to protect U.S. citizens, I think is just totally irresponsible.
The argument is simple but powerful. If Americans cannot be targeted on the front end, how can they be targeted on the back end without any process? No warrant when collected. No warrant when searched. That's a surveillance loophole big enough to swallow the Fourth Amendment whole. This isn't just a legal debate. The scale is staggering. In a single year, there were 278,000 improper searches involving Americans. That's not a rounding error. That's a systemic problem. Each improper query represents a moment when an American's privacy may have been violated, without a warrant, without probable cause, and without oversight. Renewing surveillance authorities without reform, in light of these numbers, isn't neutral. It's a choice. This debate comes down to a single, unavoidable question. Can the government collect vast amounts of data without suspicion and then search it later without restraint? If the answer is yes, then constitutional protections exist only at the moment of collection, not at the moment of use. And in the digital age, use is where power truly lies. Treating database queries of U.S. persons as Fourth Amendment events wouldn't end intelligence work. It would anchor it to the Constitution. Because privacy doesn't disappear just because the data is already there. And the moment the government goes looking for you, that moment matters.